Good morning, everybody. I hope you can hear me. I have this microphone here. So as Kirby said, I'm the manager of the Permitting and Technical Services Group at the Oil and Gas Commission, and Kirby asked me to demystify spacing and pooling. So I've got a kind of a simplistic example that I hope kind of illustrates the foundation, the purpose of spacing and pooling. Spacing and pooling is more and more complicated as our drilling technologies are more complicated, but I'm going to just use a very simple example to kind of explain it. So oil and natural gas are minerals, and the oil and natural gas minerals constitute the mineral estate within a given tract of land. Per the rules, if you own the minerals, it means you have the right to develop the oil and gas within that tract of land. Ownership is through a deed or a lease or maybe an operating agreement. And the boundary of that tract of land is the boundary of the mineral estate, so it's a property line. You own what's on one side and you don't own what's on the other side. Even though minerals can be held in these different ways, deed or agreement, we always refer to the minerals as a lease, even if there's not a lease involved, and we talk about that boundary, that property line, as a lease line. So I just wanted to kind of set that framework, because I'll talk about lease lines, even though it may not always be a lease involved. So this is the simplistic example I'm going to walk you through. So you own a nice 2-acre lot in Weld County, and you own your minerals. And in Weld County, the Niobrara Formation produces a lot of oil. It's about 7,000 feet below the surface. And so on your lot, you look out back and you think, well, I've got plenty of room to put a drilling rig out here. I'm going to drill an oil well and produce my oil. So a well drains oil and gas from the reservoir because the oil and gas actually move through the pore spaces of the rock in the subsurface to the well, and so that's how, wells work. And you think that's great. You're going to drill that hole in the ground, the oil's going to move through the rock to your well, up to the tank, you're going to sell it, and you're going to get rich. Or you're going to be able to put braces on your kids' teeth, and they're going to be able to go to college. So the distance away from a well that the oil is drained is called the drainage radius, and that depends on the characteristics of that actual rock formation. But if your well is going to produce the oil from your neighbor's property, it's actually going to move from there in the subsurface at 7,000 feet, move from their property through your property to your well and up to the surface to go into your tank for you to sell to send your kids to college. The Oil and Gas Commission will not approve that well. So you say, well, why would that be? Well, by statute, the Oil and Gas Commission is charged with protecting correlative rights. And essentially what that means is the commission cannot allow a well to be drilled that's going to allow you to produce someone else's oil and gas. And how do we prevent that from happening? Well, the most basic way is through setbacks. A setback is a minimum distance from a lease line, or the boundary of the mineral estate, to the well, and it needs to be less than the drainage radius, so that you're not draining someone else's minerals. So we have a couple of rules that establish setbacks. It's like a default. For a deep well, you have to be 600 feet from the lease line, and for a shallow well, 200 feet from the lease line. So the Niobrara Formation is at 7,000 feet. It's a deep reservoir. A well has to be 600 feet from the lease line by that basic rule, kind of a default setback in the rules. And you look at the dimensions of your lot and say, well, how can I do this? I can't develop my oil. The rules are preventing me from producing the oil that I own. So by statute, the commission also has some other charges, and one is to foster the responsible development of the oil and gas and to prevent waste. So We've got protection of correlative rights, fostering oil and gas development, preventing waste. One of the ways to fulfill all three of those responsibilities is to have the authority to create drilling and spacing units. So again, by statute, the Commission has that authority. So basically, when you have a drilling and spacing unit, it says that all those mineral owners, all that interest is as one unit. The unit can't be smaller than the area drained by the well, which means you can't have it so small that, again, you're draining outside the unit. So you have to look at the drainage radius of the particular reservoir you're looking to develop, space and develop. And then there will be a setback applied to the unit boundary rather than to the lease line, again, to protect correlative rights. So you say, that's great. You apply to the Commission for an order to create a drilling and spacing unit. The unit's going to be big enough that it'll produce your oil and all of your neighbors' oil. So everyone will get rich. So just an aside, if the Commission didn't have setbacks and didn't have spacing to create units, the only way that your neighbors could prevent you from producing their oil would be for them to produce their own oil, kind of competing two wells. And so they would drill their own wells in their backyards, just like you're going to drill yours in your backyard, and it would look like this. And this is what actually happened before many states, including Colorado, developed the rules and regulations to foster responsible development. So you get your spacing order approved, but before you go hire a drilling rig, and it's going to cost a lot of money to drill this well, you go and talk to all 15 of your neighbors in this drilling and spacing unit, and you talk about how you're going to share in the cost to drill the well, and then how you're going to share in the profits, because that's what it's all about. And so you work up an operating agreement, and everyone signs in except for neighbor number 11. Neighbor number 11 is just not interested. She doesn't want to get rich. And so you and your other 14 neighbors are kind of in a quandary. You can't afford to drill the well without that person, sharing the costs. So what are you going to do? Well, the statute gives the Commission another tool that helps to foster the responsible development. And that tool is the authority to pool non-consenting mineral owners with cost recovery and a risk penalty. So the way the cost recovery and risk penalty work is that you and your neighbors are taking a big financial risk to drill this well. So the risk penalty is that neighbor 11 does not receive all of her profits from the well until you and your neighbors that paid for the well recover 100% of your tangible costs and 200% of the intangible costs. Once that's done, then neighbor 11 will get all of her share. So you apply to the Commission for an order to pool all the interests within the unit, and now you can drill the well and everybody can live happily ever after. So again, that's a very simple example. I hope it kind of shows one of the purposes of a drilling unit and how the pooling aspect works. So on a bigger scale, that example just showed if you have one tiny tract of land and you want to drill a well. But spacing also, as I said, it fosters the responsible, which means efficient and orderly development of the oil and gas resource. So if there is an area where the leases, the mineral estate boundaries are somewhat irregular, you might be able to fit a well in there and in compliance with the setback rules, but it would look something like this, and you can see that there's areas where that won't be drained. In this case, there's 8 wells, and they partially develop 7 leases. If you created drilling and spacing units, you would be able to place the wells not according to the lease lines, but according to the unit boundaries. And in this case, you would be able to drill more wells that would fully develop those 7 leases. So this is more efficient, and this improves the recovery and prevents waste. But if you live on the eastern side of the state, you know that people aren't drilling vertical wells, they're drilling horizontal wells. And horizontal wells, if you look at this aerial photograph, and you can see the outlines of with the surface features, fence lines, roads and such. Those are the surface property. You can imagine that the property, the oil and gas in the subsurface has similar property lines. So if one of those red lines on that picture is a horizontal well, you can see that one well is going to go through a number of leases. So the way to make that happen is to create a drilling and spacing unit that essentially erases all those individual property lines, and a large area is developed as one mineral estate efficiently with a horizontal well. I guess I already explained that part. So, drilling and spacing units protect relative rights. They foster the responsible development and prevent waste of the resource. So these examples, it allows the development of small leases without violating someone's relative rights. It facilitates an orderly development of a reservoir, and it also allows for the horizontal development, which is the newest technology for many reservoirs. It optimizes the recovery then from that oil and gas reservoir. So when an operator comes forward to the commission with an application for a drilling and spacing unit, they have used geologic and engineering data to determine the drainage radius for that reservoir. And looking at that, it allows the operator to request the most efficient and appropriate setback from the unit boundary based on the science, based on how the current understanding of how that reservoir actually behaves, what the drainage is like from the reservoir to a wellbore. That allows an establishment of setbacks between wells and determines the proper number of wells in the unit. So this is an example. If you look in our files online, you'll see the geology testimony. This is what that looks like, maps, well logs that explain the reservoir. Engineering testimony from actual wells that are currently have been drilled and are producing from that same reservoir. So the applicant for a drilling and spacing unit has to own minerals. There's no minimum percentage of mineral interest required. They submit their application. All the applications have the similar information that just describe what the area they want to have a unit created, the setbacks, the number of wells. They have to notice all the owners within the unit. They also notice the local government designee. Their testimony is the geology and engineering data. There can be protests. If there's a protest, it'll go to hearing and with testimony before the commission. And the commission approves the spacing order. It's effective immediately. Pooling is similar, except that there are preliminary requirements. There first of all has to be a unit. You can't pool if there's no unit. The non-consenting unleased owners, in the example, neighbor number 11, have to have been provided an offer to lease or to participate as a partner. If the minerals are leased by another oil company, then that oil company has to be given the opportunity to participate in the well as a partner. Then the application is very similar to a spacing application. The notification is similar. The testimony, rather than being the technical, geological, and engineering testimony, it's a certification that those notices have happened and that the non-consenting owners that are being pooled have been given the opportunity to lease or to participate. Of course, there can be protests by those non-consenting owners. Then it goes to hearing before the commission, and it can be approved by the commission. So this was a very, very simple illustration, like as I said at the beginning, it's much more complex, and different regions of the state have different elements within their spacing orders because they're specific to the reservoirs that are being developed, the types of wells that are being drilled. Here's our website. It shows where you can find the hearing schedule, which is set a year in advance with all the deadlines for applications and protests, and then the links to the applications. And then here's where you can find the rules. The 300 series rules have the setbacks. The 500 series rules explain the hearing application process. And the statute, the Oil and Gas Conservation Act, is available on our website on this rules page. It's just listed as Appendix 5. So that's all I have. Are there any questions? Yes?
Let's take a microphone.
Oh.
We have a microphone on that side of the room.
Hi, Jane, my name's Troy Swain. I'm the LGD at Will County. What's the answer, the layman's normal answer to somebody who's being force pooled and they say, well, I don't want to be force pooled because then I'm liable for everything that happens with a well, or I have some sort of liability from all the, if anything comes up. I don't want to repeat what they say, but.
Yeah. Well, so, you know, the rules require that they have been offered a lease, or the other choice is to be a participating working interest partner, which means, yes, you're liable for the ongoing operations and any incident that might happen. If you lease your minerals, you're not liable. You're selling the rights to develop those minerals to the oil company. They have all the liability. So those are the two options.
Is that, when you say liable, is that a financial
Yes.
for operating the well?
Yep.
And I think the example I'm more looking for is, do they get, the argument that gets presented is, well, we're involuntarily being force pooled, we're liable for something. I mean, I can see money coming out of your lease payments to pay for the well, that's fine, just like you do as an operator. But I think what they're focused on is, in the end, if the well's abandoned and there's cleanup and different things to occur, do those people ever be held responsible for that in the real world, or is it just, I've always explained it, it sounds more like a lawyer's argument that, yeah, you could be liable for something down the road. Has it ever happened? Have pooled people been drawn in to become financially responsible for an orphaned or abandoned well?
I don't know. You'd have to ask an operator if they went to a working interest, a pooled partner like that, if they actually go to them and say, okay, we just plugged the well and here's your share. But according to our rules and statute, that is how it works. That person backs in as a working interest partner. So oil company A and oil company B are partners. One owns 20%, the other owns 75%. Every cost associated with the well, they pay their percentage. And if you are a pooled individual that owns your minerals, whatever your share, you would be liable for that. And whether the operator actually goes to them and says, you owe me $25 for your tiny share in the cost to plug this well, that I don't know, you'd have to ask one of the oil companies if they actually pursue that. But that's what it means to be pooled, to be statutorily involuntary pooled.
And that, I was trying to find if there's any real world examples, because that is given as an argument against being force pooled, but they typically they want to stop the entire project.
Right.
It's not really about themselves.
Right.
In your example, presumably all 14 of the neighbors owned their minerals?
Yes, yeah. It
How
was
is
a
it
very simple example.
How is it complicated if half of those 14 are only surface owners and don't own their minerals?
So spacing and pooling only affects the mineral owners. So if half of the neighbors had leased their minerals to an oil company, then the neighbor that had the idea to drill the well would have had to deal then with those oil companies because, again, as I explained at the very beginning, ownership can be through a lease. So if oil company A went and leased half of those owners, the neighbor that started the whole project would go to oil company A and say, hey, I'm going to drill this well. And it would be the same conversation with that oil company who is now the mineral owner. Do you want to participate? You want to pay your share? So.
Hello. Hi.
Yes.
There's two questions I have. You mentioned the difference between tangible and intangible. Could you help me understand a little bit more what tangible versus intangible means? Because you mentioned 100% recovery of the cost of tangible and 200% intangible. And then the other question is, so what is the typical lease rate for if you're a participant? What do they typically get versus a lease? I'm trying to understand the value of taking on the liability that you just described.
So for tangible and intangible, tangible is equipment, the wellhead, the production facilities, pipelines, all of that. Intangible is the permitting costs. You have employees, you have to hire people to design the well and all of that. So that's the intangible. It's, I don't have it right in front of me. It's listed in the rules. It's actually listed in the statute. So.
Why 200%?
I don't know exactly. That's the state law, and they did it that way. But you had another question about the lease terms and the participating. Again, that's something only an oil company can explain in terms of what they would offer as a lease and what kind of royalty it would have. You're right, there's a cost-benefit analysis that you would do, as in Troy's example. If you're an unleased owner and an oil company comes to you and says, here, I'd like to lease your minerals, and you say, no, thank you, and then they say, well, we're going to pool your interest within this. And when an operator comes to a mineral owner and offers the lease or the choice to participate, they have to provide at that time the cost estimate to drill the well. So the person has that information available to them to weigh the costs and the pros and cons of, do I sign a lease or do I not sign the lease, but then I'm force pooled and so I'm going to participate, and here's what my responsibility would be. So that's presented to the individual at that time.
Good morning, and thank you for your presentation. I'm from the city and county of Broomfield, where this is a pretty hot topic right now.
Yep.
And it came up in Broomfield because we actually have a major subdivision with a whole bunch of people who just own normal subdivision type houses who do own their mineral rights under their lots. So we had an activist group bring forward a bill to the legislature specifying a threshold, a majority threshold, to be available to force pool. And I was just told actually that provision, that majority provision, is now no longer in the bill. It's probably not going to go anywhere, is what I'm being told. But do you have thoughts on why there is no threshold with the technological changes and whatnot? We're talking, in Broomfield's case, literally hundreds of mineral rights owners now being forced pooled or having the potential of being forced pooled when they don't want to be. So any thoughts you have on that?
Officially, as in my position at the commission, no. It's the state law. That's been a law. would think since 1951, when the Oil and Gas Conservation Act was adopted by the state of Colorado, I wouldn't know. I have opinions, but not officially. I have my, yeah.
Any other questions from the audience? Can you explain for the benefit of the lay folks just what COGCC defines as waste as part of its commission?
Waste is actually defined in the statute, and when you go on the website and if you look at Appendix 5, at the very beginning of that Oil and Gas Conservation Act, it does define waste. There's several definitions. It's a little complicated. One of the things is the drilling of unnecessary wells. The thing to understand is when the Oil and Gas Conservation Act was enacted in 1951, at that time, the development of oil and gas was very different than it is now. There wasn't the ability to frack reservoirs. Reservoirs were what we call now as conventional reservoirs. So you'd have a defined structure with a porous and permeable reservoir, and there would be a drive mechanism, and the drive mechanism would be maybe a water drive. In some places, the drive mechanism is, for the oil production, is a gas cap expansion. And if you mismanage the drilling and development of those conventional reservoirs in a conventional oil and gas field, you would damage the reservoir. And that could cause waste in that you would render some of that oil and gas unrecoverable through the mismanagement of that reservoir. And if you look at the statute, not only does the commission have the authority to create drilling and spacing units, it actually has the authority to limit the rate of production on wells. And that was all about managing those drive mechanisms to maximize the recovery from that conventional porous and permeable reservoir. Well, the porous and permeable reservoirs in the United States are done. I mean, they're developed, those old wells are still producing. And so looking at the non-conventional reservoirs that require the hydraulic fracture stimulation to release the oil and gas, it's a very different picture. But when you look at the statute and some of the features of it, that's what it was about. What is the drainage radius? Not as a result of fracture stimulation, but as the result of the inherent porosity and permeability of that rock and the drive mechanism in that conventional trap. So it's kind of a different thing. So does that answer your question? Okay.
All right. How about a round of applause for Jane?